as to why Mr. Ferguson was not selected. They proffered affidavits that are not supported by the facts of this case, of what actually occurred. Mr. Ferguson drew attention to the individual that was selected over him, Mr. Gregory Ferguson, saying this individual has a racist issue and I've had problems with it in the past on the basis of race. What happens? He gets selected for the job of which Mr. Ferguson was never considered. Two, during that tenure, a hostile environment based on racial discrimination takes charge against Mr. Ferguson. Three, to most important point, what Mr. Ferguson feared the most occurred. In August of 2019, Mr. Collins was terminated for a violation of workplace policy when he was violently and aggressively yelling at an African-American female employee. See, it's not like Mr. Ferguson made this stuff up. He voiced his concerns, raised it, thus putting himself in protected activity, but they allowed him to remain under his supervision from Mr. Collins until it finally manifested into an incident where they finally had to act. So again, to answer your question, Judge Rail, the combined best evidence that we have that this was non-selection on 2017 was on the basis of race was because, one, Mr. Ferguson was very qualified for the job. How do we know this? He was operating in the position. Two, he was recognized for the operation of the position, and the reasons proffered by WMATA simply don't make sense.
He was put on a performance improvement plan. Is that right?
Judge, by WMATA's account, he was, but when and why is what is begged the question, and the record does not support it. The trial court found that Mr. Ferguson didn't proffer Mr. Ferguson did not provide a legitimate basis for his defense that these were pretextual. They were actually based on race. But looking at the record, it's actually the opposite. What's presented is, one, there were emails. In the record, there are emails that they discovered that the PIP that was allegedly presented to Mr. Ferguson didn't even look right because the signature looked transposed by their own admission. From Mr. Ferguson's account, he was never presented it. This was something that was created. And it's not just my words. If we look at the transcript, see, the trial court looked at the transcript, Mr. Ferguson, they just didn't look the right place. Had they looked at page 178, we would understand how the PIP was actually created. It was a conversation with Mr. Palmieri. When Mr. Palmieri says, oh, by the way, I was gonna consider you for the position, and this was in 2019, Judge. We was gonna consider you for the position this time, but you're on a PIP. Mr. Ferguson responds, I'm not on a PIP. Wasn't presented to me. Mr. Palmieri's response was, if you're not on a PIP, I will create one. And if we look at the emails that are in the record, that's exactly what they did. In fact, in the conversation with HR, they have concerns at the appearance of it and the way it was, never reported to HR, and it wasn't properly presented to the employee. So the creation and the words by Mr. Palmieri, oddly enough, Judge, it points out, Chief Judge, in Mr. Palmieri's affidavit, he kind of left that part out. Again, this house of cards clearly fails because in his affidavit, he doesn't point out the fact that he had a conversation with Mr. Ferguson, and he told him if the PIP wasn't there, that he would create.
I'm sure my colleagues don't have additional questions for you at this point. We'll give you a little time for rebuttal.
Okay. Thank you.
Thank you, Mr. Tucker. Mr. Gus.
All right. Good morning, Your Honors, and may it please the court. The decision by the district court granting WMATA summary judgment was a correct one. And I want to start with the failure to exhaust issue, which was pretty clear. WMATA sits in a different place in the District of Columbia. You have to file a charge of discrimination within 180 days as opposed to 300 days. There were three of Mr. Ferguson's allegations, one being the failure to be promoted to the TAMO position in 2017, the denial of the opportunity to present a program to the executive management team, and the late receipt of his paycheck in 2019. The court correctly concluded, the lower court correctly concluded that those three allegations were outside the 180-day limit. And so they were not considered because Mr. Ferguson failed to exhaust those claims. And they're backed up by, number one, the April 30th letter. You don't necessarily have to file in your charge of discrimination if there's other filings to the EEOC indicating what a employee is prepared to file his charge. But even in that letter, there's no mention at all of those three issues: the 2017 TAMO failure to be the failure promotion in 2017, no mention of the denial of the opportunity to present to EASI, to the executive management team, and the late paycheck issue. So those three allegations were properly disposed of. In terms of the retaliation claim, the lower court also ruled that Mr. Ferguson failed to exhaust his allegations under Title VII for retaliation. Specifically, that he failed to mention in his EEOC letter, EEOC letter actually what his retaliation was. He failed to check the box as well. So those claims were properly not in front of the court, and the lower court made the correct decision that those retaliation claims were not exhausted. WMATA, I want to reserve from the back end that the lower court did address Mr. Ferguson's hostile work environment. And WMATA's argument was that, first of all, Mr. Ferguson's allegations were more discreet, meaning that they weren't a pattern of a hostile work environment, but he was trying to piggyback his hostile work environment claim based on actual incidents of what he alleged adverse actions. So under his hostile working claim, he included the failure to promote in 2017. He included the paycheck issue, those issues that were properly that were not exhausted from the EEOC. So the lower court did address those issues. WMATA, in its brief, does state that we believe the hostile work environment claim was not exhausted. Again, we have the charge of discrimination. It's not in his letter to the EEOC. The hostile work environment box is not checked in the original charge of discrimination. Mr. Ferguson's
it doesn't matter that much that the box wasn't checked, right?
Sure, it doesn't matter that much, but it has to be something in particular, some narrative to show that EEOC what they're investigating. And it wasn't there. There was nothing indicating that his allegation was a hostile work environment in the charge of discrimination that would have alerted the EEOC that these were also claims that needed to be investigated. So that WMATA kept this argument in for the sake of the court that the hostile work environment was also not properly exhausted. Moving on to the real meat of the claim, the legitimate non-discriminatory reason for not promoting or hiring Mr. Ferguson to the TAMO position in 2019. This is where the facts are important here. Mr. Ferguson received a 7 on his 2019 end of year evaluation. That was in August of 2019. At that time, he was reporting to Mr. Collins. A 7 on WMATA's end of year employment evaluation mandates a performance improvement plan. what happened is that the following day, and this was given to him on August 1st, on the following day, Mr. Ferguson goes to WMATA's EAP program and takes leave. So, and he stays on leave until October 1st, 2019. In between that time, WMATA has reorganized the department that Mr. Ferguson was in. So, and also Collins is terminated for unrelated issues, terminated for yelling at a colleague. She happened to be African-American, but there's no evidence that he yelled at his colleagues because of anything to do with race. She just happened to be African-American, but that was not why he was terminated. He was terminated because he's a supervisor yelling at an employee. There's no evidence that there were any racial connotation to that incident, but he's terminated in August 16, 2019. Mr. Palmieri, because of the reorganization, now becomes Mr. Ferguson's supervisor. And this is when he has every intention to interview Mr. Ferguson for that TAMO position, because Mr. Ferguson has been at the time, because Mr. Palmieri was not supervising Mr. Ferguson until the reorganization. Mr. Ferguson is so much high up in middle management, so of course he would be considered if they were to hire for this director position. At that time, Mr. Palmieri is told that from HR that there is an employee that he has inherited that should be on a performance improvement plan. At the same time, Mr. Palmieri is observing, because Mr. Ferguson comes back off of leave in October, he actually is personally observing Mr. Ferguson's interaction with his colleagues, and he doesn't like what he sees. And at that point, he inquires with our HR department, and they reveal to him that Mr. Ferguson was the one that received the 7 on his 2019 end of year evaluation, and it mandated a PIP. That's why Mr. Palmieri, at that time, because of his observations of Mr. Ferguson, decided that, okay, I'm not going to interview him for the 2019, not interview him for the TAO position in 2019, but also the PIP needs to be formalized because he received a 7. And that's when Mr. Ferguson is placed on a performance improvement plan. But the decision not to promote Mr. Ferguson was not strictly because of the performance improvement plan. It was also because of Mr. Palmieri's personal observations. And that is WMATA's non-discriminatory reason for not promoting Mr. Ferguson.
You also have the non-discriminatory reason. I understood from your
sorry, Your Honor.
I thought from your submissions, I also understood that you had a non-discriminatory reason to the effect that there was a belief that Mr. Ferguson was on a performance improvement.
That is as well, because the 7 on the end of year evaluation mandated the PIP. So yes, it was finally formalized after the decision, somewhat after the decision, but when Mr. Palmieri learns that he's supposed to be on a performance improvement plan because of this 7, that weighed into the decision not to promote Mr. Ferguson. Your Honor, and that is WMATA's argument. I reserve the remainder of my time.
Okay. Thank you, counsel.
Thank you.
Mr. Tucker, we'll give you 2 minutes for rebuttal.
Thank you.
Briefly. Hostile work environment claims by its nature is supported by case law as seen in our brief clearly illustrate the reasons that they should be taken into consideration outside of this jurisdictional bar by simply checking off a box. WMATA's position is that these are isolated incidents and don't really rise to the level of the exception. The exception which indicates where a person in Mr. Ferguson's position can show a pattern in practice. As I stated earlier, this was in fact a pattern in practice. Sean Kamen, the same individual that told Mr. Ferguson, oh, I didn't get your application. Can you submit it again? He submits it again, and he's still not interviewed in 2017, even though he occupied the position. Second, when he's not interviewed in 2019, the same individual comes to him and said, is involved in the decision-making of non-selection. The PIP that they speak of, that arguably whether it was created and when it was created, Sean Kamen was not his supervisor, but he was involved, again, in this process. His name appears on the doctored text. How do we know it's doctored? When we look at their own evidence, Exhibit 5 and 6 in the record support 2 performance plans that were allegedly given to Mr. Ferguson at the mid-year. In it, it details a lot of information, and in one of the versions, it shows 7 that WMATA justifies as the reason for his non-selection. Oddly enough, at the last question underneath the signatures, it presents the opportunity for WMATA to indicate that he would be put on a PIP. In neither version is the PIP box checked off, showing that there was never really a reason to put him on a PIP, that it was part of a pattern and practice of racial practices by WMATA.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you.
Case number 23-7057. Marga Pierre-Noel, Ms. Pierre, on behalf of her minor child KN, appellants, versus Bridges Public Charter School and District of Columbia, a municipal corporation. Mr. Seibert for the appellant, Mr. Gerton for the appellee District of Columbia, Ms. Baum for the appellee Bridges Public Charter School.
Good morning, counsel. Mr. Seibert, please proceed when you're ready.
Morning, Your Honors.
Mr. Seibert, before you begin, I am at a loss to know why we didn't find out until yesterday that this child has not been in school, or at least at Bridges, all year long.
Oh, well, I think to directly answer that, it was not hidden by any means. I mean, this was something that the school system knew about.
Did you know about it?
Yes, I knew about it. And of course, at the same time.
And why didn't you inform the court?
Well, I guess because I think it's beyond the record for the first part. I mean, the IEP only lasted for last school year. So, I mean, this entire time.
It has a direct effect on one of the defendants, the Bridges school, if he's not even in that school.
Well, no, I respectfully disagree with that. I think that what needs to be mentioned in all this, the backstory, okay, is that last summer, they had another IEP meeting. And at that IEP, Bridges decided to take away the homebound services for KN. That's not in the record, but they decided to take the homebound services away. So my client was faced with, well, I'm not going to get any services at home. So what do I do? And she ended up finding a private school that would take him on a contingency fee basis that was opening a new school in the District of Columbia for starting this last fall. So faced with no services at home versus getting something from the private school, she chose the private school. And I think it's important to know that the relationship in these kind of tuition reimbursement situations for private schools, there's an equitable consideration where the child is more likely to end up going back to that same public school because the public school has an incentive to offer the child a FAPE. Because if the parent acts unreasonably in delaying or continuing for private school, she might get that tuition deducted or diminished. So there actually is an incentive for that public school to take the child back to offer a FAPE and offer the services he's entitled to under the IDEA. And if you want a case for that, Leggett versus District of Columbia from this circuit addresses that point.
Is your position that it makes no difference that one of the defendants, that is the Bridges School, he's not enrolled there? Is that your position? And that it makes no difference and hasn't been enrolled there for this whole year?
Well, no, I think, I mean, principally the District of Columbia is responsible for the transportation and supportive services that my child or my client's child is seeking in this case.
All right, but you've got another defendant you've sued, Bridges.
Well, I mean, I guess that I don't think any of this was hidden from Bridges. I mean, Bridges knew what was going on.
Well, I'm going to ask Bridges the same question.
Uh,
Just go ahead with your argument.
Well, I think, again, because it's capable of repetition while evading review. So in my mind, this entire time,
What's the current status?
he's enrolled with DCPS and the district continues to deny him transportation from his residence door to school and all the way back.
And the school is not Bridges anymore. The relevant school would not be Bridges. It's another school.
It's another District of Columbia public school, correct?
But there's the same issue about where and whether there would be a pickup at home.
Correct. Well, the state agency's obligation to transport the child all the way from his residence door to the school and back.
And can I just ask, what's the status of the IEP that's the one that gives rise to the dispute?
So IEPs only last for a year by their nature.
I see.
And so, you know, the failure to implement claim was only good for the 22-23 school year that it was active. But at the same time, the legal issue in this case is a broader IDEA question of what does transportation mean in the statute? What do supportive services mean? So this is the exact type of legal question that's right for capable of repetition while evading review.
Does the new IEP have the same terms as the one before us?
No, because in the wake of the district court decision, the LEA decided to take that service off. So because of the district court's action, they took that transportation away from my
So the
client.
current IEP doesn't provide for transportation services,
It does, just not the services between the bus
not
and
the
the home.
carrying services,
Right.
but
But again, because the legal question in this case is, I mean, the district court even said, the judge said himself, this isn't failure to implement. This is about what does this child require under the IDEA? What is this child entitled to under the IDEA? What does transportation mean? In general, when a service gets put on an IEP, unless that IEP is challenged, the appropriateness of that service is presumed correct. But this district court said that's not the case. So the issue in this case is about the design of the IEP, about what appropriate services are. It's not.
We take the case essentially on the idea that even though the current IEP doesn't include the disputed service, everybody's operating on a common understanding that if that disputed service were in fact within the compass of transportation under the IDEA, then it would be part of the IEP. So your view is there's still a concrete dispute about whether transportation encompasses the pickup at home, and in particular, the pickup at the door to the apartment. Because everybody thinks that even though the IEP currently doesn't have it, that's because that service was withheld by the district. If as a matter of law, the IDEA did cover that kind of pickup within the compass of transportation, then the IEP would include it.
Correct.
Is that the way you're looking at it?
Yes, and the IEP would be inappropriate currently.
I thought the way these suits arise is that a service is included in the IEP, and then if it's withheld, it gives rise to an action to challenge the withholding of that. But if there's no transportation included in the IEP, then what's the precise claim before this court now?
Well, I think the claim is the same. So quite frankly, I don't think it matters whether the service is on the IEP. I mean, IEPs are not contracts. IEPs are they're supposed to be the compilation of all of the services that the child needs under the statute. So quite frankly, an IEP doesn't have to exist in order for the child's rights to the services that the child needs under the IDEA to exist. The IEP is just the vehicle to memorialize the services. But if a service is not on an IEP, the child is still entitled to it if he's entitled to it under the IDEA.
But not if there's an agreement. I mean, an IEP could be kind of an accommodation where everybody who's at the table gets together and says, you know, we've got some disputes about the parameters of this, but why don't we all just come together and avoid all that by collectively agreeing on an IEP that doesn't deal with this issue anymore, and we're all okay with it. At that point, there wouldn't be a dispute any longer for us to.
If my client waived or didn't think that this transportation was required anymore, then yes, she would waive her right to that under the IDA, but that's not the facts of this case. She's been insisting on this service since the pandemic ended, if I can be so brave to say that, and we were returning to in-person services.
Then can I ask you a question on the merits then, if just to go to the merits? So your view is that the transportation encompasses pickup at the door to the apartment.
Yes.
And if that's true, and let's just assume for these purposes that you're right about that. I just want to explore the implications of that. If that's true, would it mean that anyone in this situation where they had transportation services as part of an IEP would be entitled to pick up at the door, regardless of whether the parent is able to, on their own, assist the child to get to the parking lot or the curb? Because in this case, I understand that the factual predicate is that there's actually not a parent, at least for some days of the week, who's able to perform to carry the child outside to the vehicle. And that's why there's a need to have somebody come to the front door and pick them up and carry the child. What I'm wondering is, suppose that this case is resolved in your favor so that transportation services is construed to at least be capable of going to the door to the apartment. My question is, would that then mean that that's what transportation services means? So regardless of whether a parent is able to carry the child outside the door to the vehicle, now we'd have a reading of the statute that would say that the parent doesn't have to do that anymore because the school is obligated to do that.
If the child's disability, if the unique needs of the child require transportation between the school bus and the door of the residence, then that service is required. So it wouldn't be required for all students with disabilities because most students can translocate themselves between the residence and the school bus.
Right. But it does put the onus then for that type of child who has that kind of disability. It puts the onus on the district to do it regardless of the parent's ability to do it.
Correct.
Yeah.
Correct. And I think that, again, I mean, all transportation conveniences parents. I mean, I think that and IDEA services in general convenience parents. I mean, a parent could provide FAPE to their child in theory. I mean, they could quit their jobs, they could homeschool. It's not a requirement other than school attendance laws in the district. So, you know, no, I think
even with non-disabled children, school bus services, it's not as if everybody can't take advantage of a school bus regardless of a parent's ability to themselves take a kid to school. And so in a way, the IDEA comes along and says that those kinds of services ought to be conformed in such a way that disabled children can get benefit from transportation as well.
With, I guess, the one caveat that in the district, there are no school bus services for non-disabled students. It's WMATA, it's the school, it's the regular buses and the train. But otherwise, yes, I agree with the statement. And I do see that my time is up, but, you know, I think that, you know, particular to the district court's decision is that, you know, we're not trying to seek an expansion of transportation. I mean, the ordinary and plain meaning of transportation is to move someone or something from one place to another. And the district court recognized that. But he thought that there was another narrower version. And that narrower version, unfortunately, clashes with other provisions of the act. And that means that he didn't do a whole text reading of the act. And only the broader definition of transportation, moving someone from one place to another, gels with the rest of the act.
So let's assume that again, just assume for argument's purposes that I'm on board with your understanding of transportation, that it's taking someone from one place to another. And here, the one place is this home and the other place is the school. So transportation in this particular context means taking someone from home to the school. Then the question becomes, what does it mean to take somebody from the home? And would you think, for example, that if it's a situation in which the child, because of this layout of the home, needs help actually getting from point A to point B within the home, just to get to the front door, that it could, the word transportation could encompass an obligation on the part of the district to go inside the home to carry the child from point A to point B inside the home and then on out to a vehicle?
So no, I think that, I mean, first off, my client's not asking for any services in the home, but going on the merits of it, or the hypothetical, I should say.
Yeah.
No, I think that under Tatro and Geradeff, the Supreme Court was clear that related services are designed for the child to reach, enter, remain in, and exit the school building. And I think that, you know, from the door of the residence to the school and then all the way back, that that's reaching and that's exiting the school building. But when you're getting ready for school, when you're dressing, eating breakfast, whatever, to get ready for school, that's different in kind than reaching school. It's a precursor, perhaps, but it's different. It's not the same as reaching. So, I mean, I do want to add a caveat that I think if a child is in a homebound program,
Yeah.
a residential program, then of course related services are required in the home or the residence. But no, when a child is just living at home, like this child, and attends day school, no, I don't think any related services are required in the home.
Right. So I'm assuming a situation in which the least restrictive environment is the school rather than the home. And so it's incumbent upon the district to help get the person to help get the child to school. And then the question becomes, in that situation, if it's necessary for the child to get to school, that someone actually come inside the home to help, then you would say, well, that's not encompassed by transportation because transportation stops at the residence door.
Correct. I think the natural reading in the context of the IDAs, it's the residence door to the school and all the way back, and nothing larger. Additionally, you know, I think it does need to be noted that, you know, the IDA does particularly talk about unique needs, and it says it all over the place. It says it in the purpose, and actually in this particular provision, the 1413G, the direct services provision, it says that when a state like the district decides that it's going to provide a regional or statewide transportation system, that system is going to meet the needs of the children it serves. And because the district has decided to take on all the transportation from the residence door to the school and back, that, you know, they have to meet the needs of those students. It says so right in that particular section of the act. And I do want to say that we're not seeking to enlarge the meaning of transportation. I mean, the adjectival phrase is only going to modify transportation. I mean, there's other types of transportation. I mean, there's military transportation. I think the defendant brought up the crime of sentencing someone abroad from the past, or even transportation to a doctor's office or to some other maybe service in the community or event in the community. So we're just looking for transportation, moving someone from one place to another between the home and the school and back, and doing that in a way that's designed to meet the child's unique needs. And then I think it should also be mentioned that, or not be lost, that, you know, the IEP team got together and they looked at this child and they said, what are the unique needs of this child? Well, this child cannot translocate himself between the door of the residence and the school bus. And quite frankly, it doesn't matter that there are stairs. For KN, he couldn't do it even if there was a flat road between the residence and the school bus. He's not able to operate his wheelchair. He's not able to wheel it himself. He has cognitive deficits that even if he could do those things physically, he might not even make it to the bus. He doesn't have the judgment that's required to do that. So, you know, I think, again, that at the heart of this case are the unique needs of this kid. And the IEP team did exactly as it was supposed to. And you know, unfortunately, then the state said, no, we don't think that that's required, and we're not going to do it. Even though their policy, when you look at their policy, it says that we're going to provide transportation from the residence to the school and back, one round trip. And actually in the policy, it says we're going to use the address that you provide us when you verify residency in the district. And the address in the record is the apartment. It's not the apartment building. So I think with that, I've made my argument.
Okay, thank you, counsel. We'll give you a little bit of time for rebuttal,
Thank you.
and we'll hear from the district now. Mr. Gurdon?
Good morning, and may it please the court. Jeremy Gurton on behalf of the District of Columbia. I welcome the court's questions on any of the issues in this case, but I think it makes most sense to start where Judge Henderson did on mootness. In our view, this case is moot as to Bridges because the student is no longer enrolled there. And the only question really is whether the capable of repetition yet evading review exception applies for the injunctive relief that is sought here. And I think that is a ultimately factual question about whether there's a reasonable probability that the student will be re-enrolled in a public school, either charter or DCPS.
Is he not already? I thought we heard this morning that he's already re-enrolled in public school, the district.
So it's not entirely clear. We have been trying for the last few days to figure out his current enrollment status. We understand that they have submitted enrollment paperwork, but he is not yet attending a DCPS school. Unfortunately, it is spring break and all of the schools are closed, so we have not been able to confirm that information. But I think the ultimate point is whether it's DCPS or OSSI, it would follow OSSI's existing transportation policy. And if they represent that their intention is to re-enroll in a public school and not to move residences, we would come up to the same problems that we're encountering here. So we think that would satisfy if the court is willing to accept their submission that that's her intention and that her intention is not to move residences. We would ultimately, in a year or two, be back here addressing the same legal question as to the district. I did want to say one thing about, in response to Mr. Seibert's letter yesterday. Our position is that compensatory education was abandoned at the district court level. He represents that they could still seek some sort of compensatory education award for the prior school year. They sought that at front of the hearing officer. The hearing officer concluded that no, under the virtual learning program, he was receiving a FAPE, and it declined to award compensatory education for the 13 days at that point that he'd been under that virtual learning program, and that's at JA 304 to 306. So they had the opportunity to appeal that to the district court and declined. So I don't think there's any award of compensatory education for that year that's on the table in this case or in any future case. So I think that takes Bridges completely out of this case entirely. So unless the court has further questions on the mootness issue, I'm happy to turn to the merits. If the court reaches the merits, it should affirm the judgment below because the IDEA does not provide states or schools with clear notice that they must enter the home or apartment complex of a medically fragile student and carry that student up and down the stairs. And I think the best support for this really comes from Murphy, which says you need to provide states and schools with clear notice. And what is a reasonable administrator going to understand this word transportation to mean? And I was comforted to hear Mr. Seibert's concession that they would not ask the school to enter someone's home. That is directly contrary to what they said in the district court at page 732 of the JA, where they said, yes, if that's what the child needed, you would need to go all the way into their bedroom and get them out of bed because our definition of transportation and supportive services has no limit other than the student's needs. So I think that they have acknowledged here that there is a reasonable limit on what transportation means. They're drawing it at the front door of the unit. I think OSSI reasonably drew it at the front door, the outermost door of a residence.
So you started by saying that there would be no obligation to go inside an apartment complex.
That's right. So
So
OSSI's,
if you have an apartment complex where the doors are all external, actually, each unit has an external door. So there's an entry to an entire complex that consists of 20 buildings. And the particular resident lives in the very back building. You're saying that the district could stop at the front, at the street, at the front, and not have to go through the internal routes.
no, sorry, I apologize if I misspoke. Under OSSI's policy, and I think this is very clear, they will go to the external most door of a residential building. So I had been imagining when I said apartment complex, something similar to this, where all of the units have internal doors into an internal space. But yes, if it's something more akin to like a row house where each unit's door faces the outside, they would go up to that unit's door because that's the externalmost door of the building. And that's been their policy for many
So
years.
if you go to the external door of a unit when it's outdoors, but won't go to the external door of a unit when it happens to be indoors. Let's just take the outdoor scenario. If there's no stairs, then I take it that the district would have somebody go to the front door, and suppose they're in a wheelchair, the child's in a wheelchair, and then the representative would get that child and wheel them to the awaiting vehicle.
Yes, under OSSI's policy, that's what they would do, and I think that's relatively common.
So, but then if the child, for whatever reason, can't be kept in a wheelchair, say because there's stairs, then at that point, it's not that transportation doesn't cover going to the front door and taking them to the bus, because you just said that if they're in the wheelchair the whole time and it's a pathway without stairs, it would be covered. So what then takes it out just because there happens to be stairs?
So I think that there's two issues, and your question goes to only one of them, which is the stairs, and if whether or not they would need to physically pick up the student and carry them. So that's one limit, I think, that the word transportation doesn't extend to. And then the other one at issue in this case, but not in your hypothetical, would be entering into a residential building, either the lobby of an apartment or a unit. And that also we think is outside the definition of transportation. So, but just focusing on the carrying aspect, I don't think any reasonable administrator reading the IDEA and saying, well, we need to provide a transportation system for students with disabilities that includes picking up physically with our arms a student who's medically fragile, has a lot of special needs.
Even though it would encompass picking that student up at the exact same door, the exact same distance, and wheeling them.
Yes, and if there's a way to navigate between an
Why is
external.
that? I mean, that's not the vehicle. I mean, your brief talks about transportation as has to be in a vehicle. So
Right.
you think the wheelchair becomes one vehicle and then the van becomes another vehicle?
So I don't think our brief was intended to say that there's nothing beyond a vehicle. I think that's the core of the definition, is vehicle transportation. When we talk about Department of Transportation or school transportation, we're talking about using a vehicle. I think OSSI's gone a little bit beyond that and said we will escort the student from the externalmost door.
Right. Getting them to the vehicle is part of the transportation, because you're picking them up at the door and you're getting them to the school, and that might entail wheeling the wheelchair from the front door to the vehicle and raising it and making sure the child's safely onboarded to the vehicle.
Yes, under OSSI's policy, yes. I think there are other school districts that might draw a line at the curb or at the bus stop, and I don't know whether that would be going as far as the IDA requires, but OSSI has established a policy that gets you to the externalmost door of a building.
You think it would be a reasonable understanding of the IDEA that all the district has to do is go to a bus stop?
So there are certainly schools that do that. The district doesn't have bus stops because the only buses they operate are through OSSI, and so they'll go to the closest curb or closest parking spot. So it's really not an issue here. I don't think the court needs to address kind of that.
No, but I'm just asking for the district's position on that. So just to test out your theory.
Mhm.
So if the bus stop is a mile away, then under that understanding, it would be the parent's obligation to somehow get their child to the bus stop, and that would be all the transportation.
I think it would be a much closer question, and I think the distance between the residence and the bus stop would be a factor the court would consider. I don't think any court has opined on that question. And if the bus stop is really inaccessible to the family, miles away, then I think you have a question of, are you really providing transportation at that point? So I think there are limits. And again, I think this all goes back to Murphy, which we think directs courts and administrators to use their common sense about what is necessary for the student and to draw reasonable lines. I think, other lines that courts have recognized include requests to transport a student outside the school district because of a custody arrangement. And the Eighth Circuit and OSSIO said, no, we're not going to require schools to do that. There's other cases where parents have asked, we want it to go to a different address because on such and such days they're with this parent. And the court said, no, you can just provide, a neutral system.
Mr. Burton, I mean, how much of these questions really relate to the meaning of transportation versus a determination about what is required to assist a student, to benefit from special education?
So I think,
I mean, if we were to determine that transportation included the act of something like carrying,
Mhm.
would there still be, a further determination that would be necessary about whether that was required for the student to benefit from education?
Yes, I think there would be. And I'm not sure that's really been explored in this case, mostly because of the student's unique needs here. He wouldn't be able to navigate himself. So I think we've focused on the definition of transportation, which we don't think, I think even Mr. Seibert's argument acknowledged has reasonable limits. You have to draw a line somewhere. And I think if you just do it at what does the student need to navigate, then you're all the way into the student's bedroom on the second floor, and you're requiring schools to enter people's homes, get them out of bed. And I don't think any reasonable administrator would think that's where the line is. So OSCE has, done a lot of work to consider where a reasonable line would be. And it said outermost door of the residence. And it said, we're not going to pick up and carry students, and we're not going to do something we think is unsafe.
So you're not disputing that the need part of it is met. You're just disputing whether transportation is satisfied.
That's right. And I think even if,
So if we were to determine that the act of carrying is transportation, we wouldn't need to remand for a determination about what was required to assist the student.
I think you would need to determine that the act of carrying is transportation. And I think you would need to determine that transportation extends all the way to the unit door. And then I think you'd be presented with the question under 1413G of whether the district has reasonably defined the scope of its transportation services as a related service provider. And in our case, I don't think even Ms. Pierre-Noel's brief contests that the district has drawn a reasonable policy that defines OSCE's services. And so in that event, if the IDEA requires this service, then it would fall back on whoever the LEA is. At the time we're talking about, it would be Bridges. Presumably in the future, it would be DCPS. So even under that scenario, the district, the OSCE would not be responsible for that.
That's just a question of as between the district and a school.
Right.
It's not a
Right.
question as to whether the need part of the.
So are you
Calculus,
conceding
that's
the
what-
need part is met?
I think given his needs, I don't think there's ever been any dispute about his
So
severe.
in this particular context?
In this particular context, I'm certainly not conceding that anytime a parent asks for something, that there's no inquiry into the needs. But I think with this particular student, there's extensive evidence that's never been contested about his severe cerebral palsy and other, needs that would, I think, demonstrate that he would not be able to navigate himself. So yes, for this case, I don't think that would be necessary, but I do think it would invoke the 1413G question. And I think just one other point on what we're thinking about when we look at transportation, we point to a number of other sources that are consistent, we think, with our definition, including the ADA when it talks about transportation systems. And none of those sources talk about lifting and carrying or entering someone's home. And I think that those are reasonable lines that OSCE has drawn, and we would ask the court to affirm that judgment. Unless the court has any further questions.
Thank you. Thank you for your argument. Ms. Baum.
Good morning. Lauren Baum on behalf of Bridges. May it please the court. We agree with the district that the case as it relates to Bridges is now moot. I apologize. I was not aware until last Friday that the student was no longer enrolled at Bridges. Bridges had received notice in late September, that the student was enrolled in a private school. When we looked into the private school, it seemed like the private school was not yet operating in the District of Columbia. It was a New York-based school. So it's unclear whether the student was actually going to be attending there, whether this was some kind of future enrollment. So I reached out to the Parents' Council asking, what does this mean? Is the student attending this school? Did not receive a response. I know that Bridges attempted to reach out to the parent. I'm not sure what response they got. At some point, They did unenroll the student, and I just was not made aware of that fact, so I apologize for that. But as it stands, there's no dispute that Bridges is no longer the student's LEA and therefore no longer has any role in his education. And so as a result, there's no effectual relief that the court could grant with respect to Bridges. And therefore, we believe the claim as to Bridges is moot. When Bridges was the LEA, it is Bridges' position that it was in compliance with the law as it relates to transportation. As you've heard, the District of Columbia is uniquely set up with respect to special education transportation. The state education agency has elected to assume responsibility for that service pursuant to 1413G. And as such, the state education agency is responsible for implementing that service if it is properly documented on the IEP. Mr. Seibert himself admitted just a few moments ago that the IEP team did exactly as it was supposed to do, which is review the student's needs, document his need for transportation and related supports on the IEP, and submit that paperwork to OSCE for implementation. At that point, Bridges' obligation as it relates to transportation is complete. While the district certainly does have some discretion as to how it provides transportation, that policy and those decisions cannot violate the IDEA or result in a denial of FAPE. If there is an exception that needs to be made to that policy as a matter of law, then it is our submission that the district must make that exception. It's also our position that the district cannot abdicate its responsibility once it is assumed. So nothing in 1413G preserves a role for the school once the state decides to provide the service. Similarly, nothing in OSCE's transportation policy preserves a role for the school in implementing transportation once it properly documents the need and submits that information to OSCE. So we believe it is clear that Bridges is not liable in this case.
Thank you, counsel.
Thank you.
Mr. Seibert, we'll give you 2 minutes for a rebuttal.
All right, well, to start with the last point, so we agree with Bridges that if you look at 1413G, that yes, DC does have some discretion in the manner it provides transportation services, but the next sentence, so the last sentence in this section says that it still has to be provided in conformity with the rest of the subchapter, which is sections 1411 to 1419 of the IDEA. And that includes the requirement to provide a free, appropriate public education, includes the requirement to educate the child in the least restrictive environment with disabled and non-disabled peers. So they have some discretion, but it still has to meet those minimum requirements. Next, I think that the district brought up something about the home being inaccessible. And I think it's important to note that there's no inaccessibility exception in the IDEA. The district is trying to engraft that language into the IDEA. I actually think it's the exact opposite. When you look at, I believe it's 1412, it says, Congress said in exchange for federal funds, states, you are going to provide a free, appropriate public education to all students within your jurisdiction. And the state understood that its jurisdiction is going to be the geographical territory of its state. So if a student lives on an island in the state, if the student lives on a mountain in the state, doesn't matter. The state understood that it was going to educate all these students within the geographical boundary. I think that Mr. Gurton brought up Comp Ed, and I do want to be clear that we received an award of Comp Ed at the administrative hearing, and it's important to remember that these claims have to go through an administrative exhaustion before they can come to the district court. So the reason that we didn't bring any Comp Ed for the latter half of the 2022-23 school year is because that claim wasn't exhausted yet, and it would have to go back through the administrative procedure first. Additionally, I think, going back to his enrollment in DCPS now, this child has the right to attend a DCPS school. So even if it is sort of still in the paperwork process, it's imminent that he's going to be enrolled in DCPS. It's not a question of whether. They can't deny him an education. He's entitled to it in the district. So lastly, I think I just want to close with what we seek in this case, which is Ms. Pierre is here for you to order the district to transport KN, her son, between the residence door of her apartment, to the school bus and back so he can attend school, receive an appropriate education with his peers.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Case number 23-1139. Mark Kim Gaskill et al. Petitioners versus Securities and Exchange Commission. Mr. Bissett for the petitioners, Mr. Alvarez for the respondents.
Morning, counsel. Mr. Bissett, please proceed when you're ready.
Morning, Your Honors. Michael Bissett on behalf of the petitioners in this case. There are three major issues here today. First, the pending motion to dismiss for petitioner Mr. Gaskill, the pending motion to supplement the record with the additional denial of forum letter submitted by FINRA on remand, and then, of course, the merits as to each of the petitioners here. So I'd like to first start with the jurisdictional aspect on the motion to dismiss. Of course, the Exchange Act provides jurisdiction when there is a final order from the SEC. Under the Bennett test, Bennett v. Speer, the elements of a final order require that there must be a consummation of the agency's decision-making process and one by which rights or obligations have been determined or legal consequences will flow. This test, the courts have held that it should be construed in a flexible, pragmatic manner. And here, generally, remand orders are not final orders unless that lack of finality is eventually resolved. So in this matter, Mr. Gaskill, his portion of the appeal to the SEC was remanded for a determination by FINRA as to who issued the who issued the denial of forum matter. FINRA Rule 13203 requires that the director of FINRA is the person to deny forum, and there was no evidence in the record as to whether it was the director or someone else. So the SEC remanded for the sole purpose of that determination.
Can I ask you about the equitable claims and whether they've been forfeited?
Sure, yes.
Yeah, so when I read Rule 2080B, it's not clear to me that there are only 3 grounds for expungement, but it does seem to be the case that the SEC and FINRA have said in various places for a long time that there are only 3 grounds for expungement. So given that context, would a party that is saying there are additional grounds for expungement have to make that quite clear, both before FINRA and then before the SEC? And how have the petitioners here done that?
Sure. So it's our position that it does not necessarily need to be outlined as to what grounds you're seeking expungement of or under. Expungement, it's been widely held that expungement is in fact an equitable remedy. FINRA Rule 2080 does not, if you look at the language itself, does not outline or state anywhere that you must submit these 3, which is A, B, and C, false, clearly erroneous, factually impossible, or the person.
I don't necessarily disagree with that, but that does seem to be the agency's interpretation of how that rule works. As that there are 3 exclusive grounds for expungement.
Right. I mean,
I agree that may not be the most natural reading of that rule, but it seems to be the reading that the agency has provided.
well, I think it's telling that first, again, it's not specifically outlined in that rule, and that arbitration forums are specifically for equitable remedies. There are no pleading requirements other than to state sufficient facts in a statement of claim submitted before FINRA. So there are not elements that must be met in a pleading like in a state court proceeding. So I think it would be unfair for the petitioners to be held to a higher standard, specifically seeking expungement under an equitable remedy when an equitable remedy is necessarily the part and parcel of the claim that they're seeking. Additionally, it's our position that although not explicitly stated in the statement of claim to FINRA that they were seeking equitable expungement, again, that is what they were seeking, but they did mention specific allegations that the public disclosure of the patently false allegations herein does not offer any public protection and has no regulatory value. That if not expunged, customer dispute disclosures will mislead any person viewing the claimant's central registration depository record and will not provide valuable information for decision-making, and also asked in the relief section for any other further relief that the arbitrator deems just and equitable.
I mean, if you put aside the kind of boilerplate language in the last part of it, it seemed like the rest of the items that you read, they were just adjuncts to the argument that there's false statements.
Well,
It really seemed like those were just bound up in the claim that under the explicit items that are set out in Rule 2080 about falsity.
right. And again, it's our position that you don't necessarily need to put in the statement of claim that I am seeking expungement based on equitable principles, that the nature of an expungement claim itself is seeking expungement based on equitable principles, because there's necessarily a weighing of the equities when an arbitrator or judge or anyone determines whether expungement is warranted in a particular circumstance. And here, the petitioners did state under the ABC, the false, clearly erroneous standards, but they're also stating here in that language I just described that it's a totality of the circumstances argument here, that they're saying, regardless of whether it's false, this will mislead people in viewing their public disclosure on the broker check record. And because of that, they're asking for expungement.
Yeah. In considering whether this is a new rule that FINRA made that would have to have approval by the SEC, wondering if you can help me understand what precisely petitioners think is the new policy or interpretation, right? Is it about the authority of the FINRA director to withhold arbitration in this particular context? Or is the new, policy or interpretation something about whether collateral attacks are allowed in a FINRA arbitration? What precisely is the new policy or interpretation?
So if I understand the question correctly, is it the fact that the director of FINRA is essentially issuing a blanket rule bypassing the rulemaking procedure? Is that the question?
Right. Well, that's one of your arguments, but I'm wondering what precisely is the new policy or interpretation that you think would require SEC approval?
So here, the director of FINRA is essentially instituting a blanket policy that says anyone seeking expungement of a disclosure that previously resulted in a prior adverse award is ineligible from seeking expungement in this forum. That is not listed anywhere in the rules, and this is a blanket rule that is not contemplated by the plain rules of FINRA 2080 itself and under principles of equity under the Exchange Act.
Seems very specific, though.
And it is, and I think part of that argument is that the SEC declared that the director was making a case-by-case determination for each of these occurrences. However, I cited to an occurrence where a prior petitioner was able to seek expungement based on a prior adverse award. So this isn't a case by case, or excuse me, it's not, I apologize if I missed my point there, but essentially what the SEC is arguing is that the director made a case by case determination, but there's no facts in the record to support any analysis or case by case determination here. It's just the fact that they were
The
prior
more
wa-
specific idea was that these were impermissible collateral attacks. So is it your position that the FINRA arbitral rules or the FINRA rules generally do not say anything about collateral attacks? Because they do suggest, I mean, there are rules that suggest these arbitrations are final. So maybe it's fairly implied from that you can't make a collateral attack.
right.
Are
And
you
so,
suggesting that that is a new interpretation, the bar on collateral attacks of FINRA arbitrations or arbitral awards?
I do think that the SEC placed upon the director of FINRA's determination this collateral attack piece. Nowhere in the denial of forum letters issued by FINRA does it state that this was a collateral attack on these awards. They just state we are ineligible because of this prior award. But as outlined in our brief, it's our position that this is not a collateral attack on the award. The relief requested by each of these petitioners is removal of the information from the public database that describes this award, broker check, and or the CRD that populates the information there. It's not seeking to vacate the award. It's not seeking to reclaim any of the damages that were awarded in the underlying arbitration. It's not seeking to affect that original arbitration award in any capacity other than to remove the public disclosure of it in this database.
I've got a question. I want to ask you about the lead plaintiff, Mark Gaskill. And I think I heard you say that it was remanded simply for the director to make the decision. But if you look at footnote 32 of the commission order, it says, because we are remanding to FINRA the proceedings of Gaskill, so forth, we reserve the question of whether the same analysis, that is the non-FINRA arbitration that this arbitration service of Portland performed for Gaskill, whether the same analysis would apply. And then it says, on remand, the director should consider that question in the first instance. Now that April 25th letter doesn't explicitly say, oh, by the way, the fact that Gaskill came from Portland doesn't change the analysis. If we decide that we don't have jurisdiction over Mr. Gaskill, what's your position on whether we should remand to let FINRA answer the question that the commission told it to answer in the first place?
So if jurisdiction is not found, then we would request that it be remanded. And I think that would be the appropriate solution here rather than dismissal of the petitioner entirely. But to remand to address that specific issue, I don't think that, the SEC makes pretty clear in its decision what the effect of its order is really stating. I'm not sure what the difference between a final arbitration award in one forum versus a final arbitration in another forum would have any impact on the analysis here. But the SEC does make that statement as a footnote in their order.
It must feel there is some room there to have a different analysis. I think, or they wouldn't have said, we're not going to reach that issue because it didn't come from FINRA.
Right, and on remand, FINRA did issue a new order, a denial of forum order. And again, they did not specify any further distinction between Mr. Gaskill's arbitration award issued in the Portland forum versus FINRA. They again stated that this is a collateral attack on a prior adverse award, and therefore he is ineligible from seeking expungement in that forum.
Thank you.
Thank you, counsel. We'll give you a little time for rebuttal.
Thank you.
Mr. Alvarez.
Good morning, Your Honors, and may it please the court, Paul Alvarez for the Securities and Exchange Commission. Your Honors, as the Commission's brief makes clear, this court lacks jurisdiction to consider the petition for review by Mr. Gaskill because there was no final order disposing of his application. The Commission did not conduct a 19F analysis that it did in disposing of the remaining petitioners who are properly before this court. And as counsel acknowledged, the Commission remanded Mr. Gaskill's application to FINRA. Because there is no final order as to Mr. Gaskill's application, because this court sits in review only of final orders of the Commission, this court lacks jurisdiction to consider his petition for review, and therefore it must be dismissed. And on that point, you asked about remand, Your Honor. I don't think that this court has anything to remand because the petition is not properly before this court. So I believe dismissal would be the appropriate remedy here and not remand.
Well, we're reviewing, you may be right, we're reviewing the commission order, and that order, as I read it anyway, said to FINRA, not only does the director have to make this decision, but there may be a different analysis because it comes from a non-FINRA
That's right.
arbitration.
Yes, that's right. And so I think what the issue here is, Mr. Gaskill's case is presently effectively still before FINRA because he hasn't submitted an application to the Commission for review of FINRA's order. Now, of the director's decision to deny access. Now, in that petition, I don't want to speak for what they can argue, but they certainly could argue, well, FINRA's director didn't make that determination. We would like for FINRA to make that determination, or they could request that the director make that determination in the first instance. Is he not out of time? I don't think he's out of time for seeking commission review of FINRA's.
Of the April 25th.
Of the April 25th. He may be, I don't know that necessarily. I think he might still be, he hasn't, but the point is he hasn't brought this to the commission's attention. So there's really no analysis that the commission has done on that issue. And because of that, there's nothing for this court to consider because his case effectively is still in front of FINRA because he hasn't brought it to the commission's attention in the first instance. I recognize it's a weird situation, but that is kind of where we're at.
I mean, I guess he could have sought review in that proceeding as a protective matter, even if he thought that there was jurisdiction here, he could cover himself by seeking review through the other channel.
Absolutely. I think that's what he should have done, right? I mean, he should have sought the commission's review of the April 25th order immediately. And because he still had the 60 days from the early April commission order. So that would give him to about June. And I don't know, I couldn't tell you whether the commission would have resolved the issue in that time frame, but at least he could have made the attempt to do so and attempt to kind of then join the petitioners here with the final commission order and perhaps bring the commission's order resolving his April 25th letter in as a related case or combine the two, but he never did that. So we are.
I don't want to get into the wild blue yonder, but
Yeah.
You are an expert. Can you think of why the fact that the arbitration took place in a non-FINRA site would make any difference? These arbitration services, Portland and these others, do they have something different from FINRA, or do you know?
I don't know, Your Honor. I think it was merely, and again, I don't want to speculate here as to what the commission was thinking, but if I were to guess, it looks like in certain instances you have arbitrators that are actually FINRA arbitration, and Mr. Gaskill's was years ago. I don't know whether it was before the NASD or before FINRA. I don't know exactly. So I hesitate to say. I'm sorry. I wish I had a better understanding of what the commission's.
What was this, Portland?
Yes.
Yeah.
Right. So a state versus, say,
Yeah.
This is an arbitrator that is under the auspices of FINRA. So,
All right.
But so we believe that the petition should be dismissed, and turning to the commission order as to the remaining petitioners who are properly before this court, the commission acted reasonably in concluding that the Director of Dispute Resolution Services at FINRA acted consistent with FINRA's rules and with the Exchange Act in denying the, yes.
Ask you here, are the decisions here that were made by the FINRA director, are they a kind of new interpretation or policy that would require SEC approval?
No, no, not at all.
You know, both with respect to the type of authority that the director can exercise, as well as to whether you can bring collateral attacks in the FINRA arbitral form.
Sure. So I think these are not, this is not a new rule. I know they've, my friend on the other side has claimed that it is. But the rules that, you know, as you alluded to in your questions earlier on, the rules well established that there are no collateral attacks. And I point this court to Rule 12904B and 13904B, which states that all awards are final and shall not be subject to further review or appeal. And that establishes that collateral attacks on awards are not permissible. And I don't even take my friend to be arguing that collateral attacks could occur, that petitioners could challenge the merits of the underlying original adverse arbitration awards against them.
So finality, I mean, in the federal court context, you know, the finality requirement implies some kind of limit on collateral attack.
Yes.
But there are exceptions to that. And so there's nothing specified in the FINRA rules about collateral attacks or perhaps situations in which something that looks like a collateral attack might be brought.
No, there's nothing specifically saying you're not allowed to collaterally attack, but I think fairly interpreted, each of the rules do prevent such attacks. I think you again look to 13904B, 8312C of FINRA's rules states that where there is customer dispute information that gives rise to a final award, that information shall be made permanently available on broker check and in the CRD.
And so you think that's reasonably and fairly implied by the existing rules?
Yes, absolutely. I think also, you know, with respect to the director's authority, that's also a longstanding rule that permits the director to engage in a gatekeeping function to ensure that, you know, FINRA is utilizing its limited resources in a way that would make the arbitration forum most efficacious and most efficient, and preventing collateral attacks on awards that are meant to be final is a reasonable exercise of that authority. I think the other thing that you need to keep in mind, Your Honor, is that in addition to FINRA rules, which place an emphasis on finality, the Federal Arbitration Act places an emphasis on the finality of arbitration awards. And I point this court to 9 USC sections 10 and 11, which provide the grounds for when an arbitration award can be vacated or modified. And the vacator section is section 10, and in the vacator where they allow vacator of the award where the award was procured by corruption, fraud, or undue means, or where the arbitrators were corrupt, evidently partial, committed prejudicial misconduct, or exceeded their powers. And modifications of arbitration awards in section 11 may be made only where there has been a scrivener's error or where there is some other error that has not affected the underlying merits, that does not go to the underlying merits of the award. So those two provisions express Congress's policy and interest in ensuring finality.
So are you suggesting that that goes to the reasonableness of what the SEC did because it's consistent with the Arbitration Act?
I'm saying that shows that the SEC acted reasonably in interpreting the rules as they existed and in interpreting the framework that Congress set up for the review of arbitration awards, and that emphasis on finality makes clear that collateral attacks, even though there's not an express rule that says, well, you can't have collateral attacks, fairly interpreted the rules that FINRA has established and the rules that Congress has set up regarding the review of arbitration awards clearly shows that collateral attacks are not permissible. And again, I don't take the petitioners to be arguing that they could collaterally attack, but their argument instead is that they're not collaterally attacking the awards because they're instead only seeking to expunge the allegations that gave rise to those awards. But there's a number of problems with that argument. And I can see I have 15 seconds left if I may, continue on this point, if that's okay.
Sure.
The problems with their arguments are threefold. The first is that argument ignores the fundamental fact that the original arbitration panels in this case found each of the petitioners liable. And that finding of liability is critical here because the grounds for seeking expungement go to, as Judge Srinivasan stated, they go to the issue of whether the allegations, and Rule 2080 states allegations, claims, or information was clearly erroneous, factually impossible, or false, or that the associated person wasn't involved in the misconduct that was alleged. But by finding the petitioners liable, the arbitration panel in the original awards necessarily made the determinations that the allegations were not clearly erroneous, were not false, were not factually impossible, and that the associated persons, the petitioners, were involved because they would have to make those determinations, if not explicitly, certainly implicitly, in reaching a finding of liability. The second problem for the petitioners in their argument that they're only seeking to expunge the allegations against them is that they are actually collaterally attacking the underlying awards, not just by seeking the expungement of the information, but by challenging the awards themselves. I'd like to point this court to footnote 9 of the commission's brief, which begins on page 32 of the brief. And in that footnote, the commission details the nature of the expungement request that the petitioners actually made to FINRA. And in those requests, the petitioners argue that they were entitled to expungement because contrary to what the original arbitration panels found, they did not act negligently, they did not make misrepresentations, they did not provide false or misleading information, they did not act fraudulently, they did not engage in churning, they had no fraudulent intent, they did not make unsuitable recommendations, and they did not violate the federal securities laws. Each of those challenges goes directly to the underlying legal determinations and findings of liability made by the original arbitration panels, and thus those arguments constitute impermissible collateral attacks.
What's your third one?
The third one is simply just as a practical matter, what the petitioners are arguing for is an unfettered access, even decades after the fact, to the arbitration forum that they could argue on any argument outside of 2080B1, which we think is very clear that those are the only three categories for expungement, that they can make any argument at any time, even if there was a finding of liability. So as a practical matter, that standard that they're proposing is directly contrary to FINRA's interest in maintaining the finality of arbitration awards and ensuring that FINRA's resources are well spent and used on arbitrations that are properly before the arbitration forum. Unless this court has any further questions.
I do have one more question, and it's a footnote again.
Yes.
Tell me what role the court that has to confirm expungement relief has. Is it just a stamp of approval? Can it second guess the award of expungement?
Well, so I think the court has to, sit in review as courts would. I don't think it's a rubber stamp necessarily, but the way that
it says the award must be confirmed.
Yes, that's right. So
Is it
I'll try and be very brief because prior to this requirement being implemented into the rules, arbitrators had themselves been able to just expunge records without resort to a court. And NASD and now FINRA created this requirement to provide an extra check and to allow themselves to oppose. And the categories in B1, FINRA said, as the commission order approving NASD Rule 2130, which became 2080, NASD and FINRA said that they would not oppose expungement requests where the three categories in B1 were met, but that they would continue to oppose expungement requests to the extent the arbitration panel made findings outside of those three. And so
That's what the,
that's where that comes into play.
thank you.
Court has any further questions? Thank you very much, Your Honors.
Thank you, counsel. Mr. Bissett, we'll give you 2 minutes for rebuttal.
I'd like to use this opportunity to address a few of these points that were made. One is that the confirmation portion, that FINRA would not oppose when expungement is recommended under the A, B, and C standards. That would necessarily mean that expungement is allowed if there are other reasons for expungement, like equitable expungement here. That is a scenario where you would be required to name FINRA, and FINRA could oppose at the court confirmation phase. As to the finding of liability by the previous arbitrators, attached are the awards that were made in each of these cases. The awards simply state finding of liability jointly and severally for an amount and damages, all of which were significantly less in value than was what was requested. There is no specific findings as to, for example, Mr. Gaskill is liable for negligence, Mr. Gaskill is liable for unsuitability. None of those findings are present in any of these awards. So to say that it's necessarily a collateral attack because these petitioners are now seeking to expunge based on any one of these arguments is just not within the evidence. If you look at Mr. Wetzel's award, for example, the customers were asking for over $170,000 in damages. Mr. Wetzel, along with the broker-dealer firm, was found liable for $1. Not a single fact said why he was liable, whether it was the broker-dealer or whether it was him specifically. And additionally, you're allowed to allege alternate theories of relief in a statement of claim. Just because any of these petitioners are seeking expungement under something that the director may consider to be a collateral attack doesn't mean that they're not allowed to seek expungement under alternate theories of relief, such as equitable expungement or any of these other that I've outlined previously.
Okay. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you.